आवाज येतोय आता?
हो येतोय येतोय.
आता येतोय.
Yes, sir.
Sir, please start.
One minute. Now it is okay. Who will operate the
Yes, sir.
PPT? Shubham
Mr.
will
Shubham.
operate the
Shubham.
PPT or
शुभम
सर हाँ
okay.
पीपीटी दिखाई दे रहा है सर, एक मिनट शुभम बात करेगा।
हाँ 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 हाँ
सर आप नेक्स्ट बोलते जाइएगा, मैं नेक्स्ट पीपीटी ऑन
ओके
कर दूंगा।
ओके
नेक्स्ट
ओके
पेज।
ओके 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 ठीक है
क्लियर?
या
हाँ प्रसाद सर करिए
So
स्टार्ट.
sorry for the
Shall we begin?
interruption and trouble to everyone.
Yeah.
Thank you
No.
Shubham
Yes.
for connecting.
Yes sir, shall we begin?
Yes sir.
Yes yes.
Yeah, shot is ready. 1 2 3.
Yeah.
So good afternoon, respected speaker, Dr. NB Dahibate sir, retired principal from Pune, and colleagues, dear colleagues, all the ILA office bearers and participants. Welcome you all. On behalf of the Indian Library Association, I extend a very warm welcome to all of you for the day 3 session on Skill Enhancement Program on Research Methodology and Innovation in Scholarly Communication. Over past 2 days, we have had enlightening discussions on critical themes. On day 1, we explored research ethics, where Dr. Prakash Makwana emphasized the importance of integrity, plagiarism, accountability in research practices. On the day 2, Dr. Mangala Hirwade madam, gave us deep insights into innovation in scholarly communication, highlighting the role of open access, digital platforms, and then various types of copyright laws. And then today is the third day. On day 3, we shift our focus on an equally significant theme, which is part of trademarks, patents, and copyright laws, IPR. That is the patent filing process and case examples. Patent filing process and case examples. In the current era of knowledge-driven economies, protecting intellectual property is vital, not only for researchers and institutions, but also for fostering innovation and societal progress. So understanding the process of patent filing and learning from real case studies will definitely help all of us, and appreciate how research outcomes can be safeguarded, protected, commercialized, and translated into practical solutions. So with this, now I would like to invite Dr. Viresh Hanchilal to introduce our today's guest of speaker and honorable speaker Nandakumar sir. And may I now hand over to Viresh sir.
Thank you, Dr. Prasad, and good afternoon, everyone, and respected dignitaries of the webinar and my professional friends. I deem it my pleasure and honor to introduce our today's eminent speaker, Dr. Nandakumar Daivate, sir. He is the former Principal Technical Officer of CSIR, National Chemical Laboratory, Pune. He has a rich experience of working for more than 39 years in NCL Pune as Special Library. He did his PhD from Savitribai Phule Pune University, Pune, in the year 2011 on the topic Patent Literature in Chemical Sciences and Analytical Study of Selected Countries. He is known for his special experience in providing patent information, technical and consultancy services to a specialized chemical, pharmaceutical, and natural sciences users, and worked on STN international resources for searching chemical information and data for chemists, industries, and researchers. He has assisted scientific community and provided patent information service, translation service, and initiated value-added services and revenue generation culture in LIS profession through information services to users. Believing in continuous education and skill upgradation, he also completed the core general course on intellectual property and a 6-week online course organized by World Intellectual Property Organization, WIPO, Geneva in the year 2000. He has delivered several keynote addresses, invited talks in many national and international conferences, seminars, and workshops. He has introduced to scholarly communication and published 3 books and more than 90 research papers in national and international journals, conference proceedings, and in edited books. He also served as an editorial committee member in 4 prominent alliance journals. He has served in many capacities at various universities, institutes of national importance, and R&D institutes. On his academic assignment, Dr. Dahipati sir has visited many countries such as UK, France, Spain, Germany, Italy, Brazil, Malaysia, China, and USA. In recognition of his exemplary contributions to the field of library and information science, Anant Narayana Gore Award for securing first rank in belief science in Marathwada University, Aurangabad, an adjunct professor award by Shivaji University, Kolhapur, Grantamitra Puraskar Award by Parnekar Maharaja Granthalaya and Public Library, Parner, District Ahmednagar, Certificate of Excellence Award by Karnataka State SC/ST Professional Association, Gulbarga, Karnataka, Sammanam Patra from Council of Scientific and Industrial Research, CSIR, New Delhi, for appreciation towards the contribution of services to CSIR, and also he has received Samman Patra Award from Maharashtra University and College Librarians Association, Mukla, in the year 2023. He is a life member of professional bodies such as ISLA, Pulisa Pune, SIS Delhi, ILA New Delhi, and many more. Friends, we are really lucky to have such an illustrious personality and an authority to deliver a talk on the topic patent filing process and case example. Much ado, may I now invite Dr. Dahivate sir to take the session. Thank you, sir.
Thank you, Viresh, for nice wording. Thanks a lot to everyone. Now, of course, I am just doing whatever I am just done in my working hours. Uh, Basically, I helped all the scientific community for searching patents, patent literature, and prior art searching, basically. So, basically, one thing it is correctly said that the only thing that keeps us alive is our brilliance. The only thing that protects our brilliance is a patent. This is by Edward Land in 1976, rightly connoted the sentence that whatever our brilliance is there, that brilliance is protected by the patent. So, patents is nothing but a very important document in everybody's life whosoever invents something new concept in the area of their research activities. Can you go further? If we look into the background of the patents, then we will see that patent is coming under the umbrella of IPR, and patents are most important IP created by the innovators. And this IP is not only created by reading or writing or experimenting, but it is a creating of a human mind, human brain. The all new concepts coming from the human mind and brain, they are worked on the experience basis, and they are just converted into the new developing ideas. Properties are definitely of two types. One is tangible, another is intangible. We know the tangible properties, but in intangible property, we are very much aware. We have to very much aware about the abstract property, which cannot be measured in terms of certain measures. And this covers intellectual property. Intellectual property, that is creation of human and mind, is related to the intangible property. And this intellectual property is divided again into two forms, that is copyright and industrial property. Yesterday we have seen these in the PPT, whatever she has done, we are just excluding the part. It is very difficult to cover everything, but we are trying to focus more on the core areas of this. Can you go ahead, please? Shubham, please go ahead. Shubham, hello.
Shubham.
So, one thing is there, rights related to the intellectual property are commonly called as intellectual property rights. And these intellectual property rights are the legal rights which are resulted from the intellectual activity from the industrial, scientific, literary, or artistic field, whatever may be the means of coming the novelties. The rights
Easily
are granted by the
correct,
state
right?
or government to creators. Who are the creators for them? They are giving. Don't go ahead. You are going ahead. Shubham, go back so that people will look into that. Creator on developing innovative creations to exclude the unauthorized commercial use by the others. This is more important, and that's why intellectual property and intellectual property right are most important for us. 1 minute. Shubham, you are going far away. Now it is correct. You just keep the pace with this. Many higher learning institutes now, like IITs, universities, IIMs, or even ICERs, they are even more than, I will tell you, universities, along with universities, engineering colleges, science background colleges, even some art people, they are also filing patents in coming centuries. Many higher learning institutes, universities, industries have started developing and creating awareness about IPR issues, IPs, and establishing IP cell and unit in their organization to manage IP and IP cell properly. The individual or company who has the rights of a particular patents, they are called as right owners or right holders of the IP. Can you just go ahead, please? The types of IP, please go ahead. Please go ahead. In case of types of IP, Madam has discussed yesterday, but TRIPS has fixed the types of properties based in 1994, and it provides all the worldwide all the worldwide uniform system for identifying the intellectual property, in which seven properties, as mentioned, they are saying that patents, trademarks, geographical indicators, industrial design, trade secret, plant variety, copyright, layout design, and semiconductors. Whatever you have seen, the different example, they are covered into it, and they are dealing with the particular aspect of intellectual property. Say for example, patents are dealing with the novel ideas, trademarks are dealing with the services and services and different products they are preparing and identifying from the common product for the marketing purposes. Geographical indicators are coming from the region, particularly where that particular property is very popular and that has a special characteristic with the region. What that region may be state or whatever may be, that is coming into the issue. Furthermore, industrial designs. Just go back. Go back. It is not flashing the PPT.
Shubham,
Industry.
screen sharing stop.
Okay.
Shubham,
Ah. So I will just continue with the something. Geographical indicators. When we
hmm,
say geographical indicators, no need
hmm,
of making any good cities or anything, any small village, taluka place, anything. But along with that region, it is known as, and examples are quite elucidated. Yesterday we have seen industrial designs are coming from the industries, and they are dealing with aesthetic creations which are very good to see and which are very good to use, which are unique also. Plant varieties are going for the agriculture and horticulture innovations, and similarly copyright and related rights which are known to us since beginning. We are just following all the copyrights related activities, and that is known to every library professional, so there is no need to highlight on this. But layout design and semiconductor designs, ICs, and all these things, they are coming under this area. Then next slide, please. Then IR related laws and conventions are many. Initially, Paris Convention was, please go ahead. Paris Convention, now, please go ahead. Huh. So Paris Convention, which was just started and just it was just initiated, that was for the protection of industrial property, trademarks, patents, and governed by the domestic legislation, followed by the Berne conventions also. And these conventions are revised quite regularly, and these trips in 1994 they have fixed the properties, and they have particularly they have added many things additional to the Paris and the Berne convention, and all the IP property acts are just taking care of the all intellectual property, which is essential for filing. And every year on 26th April, every year we are celebrating as World IP Day to just make honor for the all innovators. They have shared their innovation for the public or society well-being of the society. Can you just please go ahead? Go ahead. Then patent, if you see the overview, then in few minutes I will just see the overview because this is the basic, and then we will go for the filing patents. In the patent overview, the word patent originates from the Latin word that is patier. This patier means to pay, to lay open. Only open document in all the scientific area is patent. The meaning for this open document is that patent should be known to everyone. What is filed by others in the respective area should be open to others so that they can use that innovation, they can think on that, and they can again contribute further for the further development of knowledge. And that is why patent is such a document that is kept open for everyone, everywhere, anywhere you can use it. It is like a open access. But open access and this patent have a little bit difference, because open access means it covers many things, and open access publishing and all these things. But open patent literature, basically it is open because we have to read it, we have to file the suits against if it is wrongly patented, and all these things. For that it is kept open, and it is for everybody's public inspection, that is kept open. Literary patents meaning open letter. It is just certificate means it is a literary patents means it is a patent. When patent is granted, a certificate is provided to him, so that it was coming under the royal seal of the patent offices and all these things, and which is the royal degree or certificate granting exclusive right to that person who has invented the thing. A patent grants rights to innovator for developing any device, substance, method, or process. Either he can use for himself or he can just share with others with the licensing agreements and all these things. And patent document is such a document that it will describe complete scientific procedure, complete technical know-how, and practical concept embedded into that innovation. And that is why this patent document is totally different from the other documents. Other documents may hide something, but in this patent document the clear description is given. But in spite of giving the clear description, we cannot prepare that product immediately, because certain parameters are kept hidden for the purpose of revenue generation, economic purpose. That is the right given for the innovator for that purpose. Furthermore, if you see that for the patent protection in a country, it is necessary to apply. This is the unique thing. In patents, you have to apply, otherwise somebody else will snatch out that patent and they will file out. And yesterday, madam rightly pointed out that whatever you generate innovate idea till your patent filing and granting. Don't disclose it to anyone else. Otherwise, it would have a another impact on the research. So this is necessary to apply to the patent office at the country or wherever you want to make a monopoly right. You have to work on that issue. Furthermore, there are currently more than 200 patent office worldwide, and every country has its own patent office, its own patent database, whatever they granted and accepted, and as well as they have their own patent law. In spite of the patent law 1970, they have certain amendments based on their country's need, and they are updating their patent law. So it is very essential factor that every country has a patent office, every country has a patent database. We disclose the innovations filed in that country, and every country has its patent law to protect the patents at their local level. Can you go ahead? So this is basic background what we understand about the patent. And patents, basically more than 6 lakhs patents are filed in different areas. Every area you will find a common area, even you take, you will find the patents available there. And the another best thing of the patent document is that its structure. The structure of the patent document is very unique. If you want to particularly look into the particular information, they are classified accordingly. If you want to refer to title, assignees, inventors, then international patent classification is there. Abstract you want to see, figures you want to see, or prior art you want to see. Everything is well constructed and well structured, and that is why patent literature is a standard pro forma, and in that standard pro forma, everybody has to apply it so that the uniqueness, that is standard bibliographic format, will be maintained and it can be searched by anyone throughout the country. This is one. There is no world patent as such. Every country has a patent, but there is one concept that world patent application is there. When we will come to that point, but here point I am just want to explain that through PCT we can just enter our innovation into more than 150 countries wherever you want to file the patent, because patent filing, wherever you file, it is just uh, that is the affected in that country only. Suppose you filed only in India, then your patent can be used somewhere else in other countries also. Then you cannot sue anywhere. So you possibly think that this patent or my invention can be used in another countries, and accordingly you file the patents in respective countries also. And PCT is one level where you can economically file the patents. Now, how we can just get the ideas innovated. So work experience, say for example you are working in a particular field more than 20 years, plus your work knowledge also, you are knowledgeable person, your subject knowledge is very good. And if you combine your work experience and work knowledge together, and if you start experimenting on new ideas, generating new ideas, then it will bring definitely a new idea. Many scientists, what they are doing, they are reading more literature, more patent literature. The reason is that patent literature gives you the exact and very clear technical description as well as scientific description, what happened before also, and what the person has also disclosed, and what will be the future uses of this also. So many people, they are constantly watching patent in their particular field of knowledge. This is one thing. So work experience, work knowledge, when it's combined together, then it brings new idea. And when new idea, you work on that, you experiment on new idea, then innovative activities comes out. And this innovation, whatever newness you have found out after your study, then you are able to file the patent. This is one of the short summary of the patent innovation, or how you will file the patent after the innovative thing. An invention may be described as a new solution. Invention may be new solution. The problem may be old, but it can be technical solution, scientific solution, which can be properly applied for any problem. So problem may be old or new. The solution is always a new one. That is one thing. It is order of merit also. It is a new one also, and priority date is the first to file. Who will file the first, he will get the priority. Say for example, I am working with my student and my student filed the patent first, so his priority will be first. Now there is the one point here we have to notice. Then what that mentor has to do, mentor has to prove that my work was started before my student, but he has submitted it. And for this purpose, some lab record books are essential. Some experimental books are essential to keep. So almost all big industries or big organizations, research organizations, universities, where more research is conducted, they keep the research record properly. Even if a researcher left in between, the same work can be continued further by reading the lab books or research books or patent information books, whatever kept under the university or organization. So please go ahead, please continue. Uh, So WIPO defined patent an exclusive right given to any invention for his product or process which gives new way for preparing and providing solution to a problem. This they have mentioned. And all the patent rights granted are acted under the Patent Act 1970, which is amended in 1995, sorry, 1999 and 2005. A patent is an agreement between the inventor and the country or the patent office of the country, which allows inventor to exclude others from making, using, or whatever he may be doing. It is if he is using unlawful invention without the inventor's notice, then the inventor or owner of the patent can file a suit against him. And this monopoly claim or monopoly rights awarded to him are for the 20 years from the date of filing. There are two dates. One is date of publication and one is date of filing. From the date of filing, patent is granted within 2 to 3 years span, or it may take more time also if the patent is very complex. So these patent rights are protected, and that is territorial also. This territorial patent means Indian patent, as I told you, US patent. Wherever you file the patent in that country, you will get the monopoly rights. So filing of patent application to patent office is definitely a mandatory one. Any person can just file a patent. He may be literate, he may be illiterate, he may be educated, he may be uneducated, he may be having high degrees with him, he is highly professional. Anybody can file a patent, but only thing is that the four criteria yesterday madam has communicated, that is novelty, non-obviousness, inventive step, and usefulness. These are the 4 5 categories are there under which that your invention should be fixed in, then patents are granted. So yeah, I will tell you one good example. Any person can file a suit or file a patent. One boy of 12 years, he was going along with the father to cut the wood, and they were using hacksaw for cutting the wood. And that hacksaw daily they are doing, but after experiencing with the father, he understood that if we take an angle cut, then the wood will cut fast. Manually they were doing. So based on this thinking, and he cannot file the patent, but he approached to the assignee or some institute, and that institute filed the patent for him, and he is a patent holder. So whatever may be the thing, innovative idea may be generated from the childhood to anything. And that is why the many organizations, they are now, just yesterday also, Dr. Mashalkar's Panchasutri, we have just learned from the madam thing that anybody, the innovation should start from the schooling level, so that the boy, when they grow and go to the university level or during the education itself, they can just make innovative ideas. And if the ideas are innovative, they can file the patent in their countries also. So patent gets lapsed if you cannot renew the patent, or you cannot pay the proper fees to them. So your patent should be always active when it is granted. Okay, go ahead. Please go ahead. So more than 80% of the information is available from the patent, which is not disclosed anywhere, either in journal, though we are saying that journals are the primary source of primary source of information, but that is not possible. Only this is from the patents you can do that. So this importance of patents, if you relate to that, it is very essential for the researchers, scientific staff, academicians also, students, scholars, whosoever are there, they should know the importance of patent, because if you have a patent, you can have a economic source with you also. You can just monitor the best thing will also. And wherever the patents are there, patent will guide the proper solution, or develop new ideas to the new entrepreneurs, or new industrial entrepreneurs, or scientific community, or scholar, or researcher. They will give new boosting, or they can generate new technologies, new ideas, based on reading from the previous journals also, or previous patents also. So patents are used to identify experts also. There are many uses also. We can see in the next slides also. Please go ahead. Please go ahead. Huh. The main types of patents are product patent, process patent, and design patents, and now plant patents. These four patents criteria are the basic all over the globe. These are there. So main types of patent are product patents. Say for example, I said door lock is prepared, that is the product. Process of patent, how that door lock was prepared with the different designs and all these things, and that is called as design patents also. Design patent will be different, and utility patent will be different. Utility patent relates to the method of preparation and product preparation, and whether design patent will look after the design of the patent. So these will be grouped under different heads. And plant patents, now varieties of plants from the agriculture and horticulture side, they are coming into that. So, and duration is 20 years. Can you just please go ahead? I will just not take more time for here, because one thing we have to just look into that is that utility patent. I have just told you that they are the functional invention, 20 years period. Key requirement is that novelty, inventive step, non-obviousness, and industrially it should be used or applied. New type of engine and all these things, new drug deliveries, new drug, that is main thing. But in case of design patents, they are protecting aesthetic features, that is ornamental or aesthetic appearance, basically for carpentry or goldsmithy and silversmithy. All they are using all such type of things, and they are protecting their designs for the uh, particular economic gains. So duration for this is 10 plus 5, and key requirements are they must be new, original, and they must be visual in design. It should be good in look also. So these are the things. Plant varieties. Yesterday also they have madam has told duration is 20 years and key features are genetically unique varieties are there, as well as non-patentable in India. But now we are also giving patents, plant patents for the sexually created hybrid crops, and all these are seeds preparation. All such type of things are now patented in India also. But apart from these four, there are provisional applications. In India and US, we are thinking that we can just apply a provisional patent in the patent office, and just we can make a compound or boundary for our protection and get the prior art for our protection. But only one mandatory thing is that after 12 months, you have to file the complete patent, full specification to the patent office. Otherwise, these provisional applications will be cancelled. Patent of addition protects are there, then final divisional applications are there. Patent of additions means sometimes some queries comes. Please go ahead. Please change the slam. So improvements or modifications suggested from the either side, either from the patent office or from the inventor side. Then patent of addition is based on the previous filed patent. Something new you want to add within a time limit, you can add as a patent of addition also. Or divisional patents, if a patent is very lengthy, then you can break the patent into two halves, and same under the same priority date, you can just file there. They've also, and as I told you, the users of patents are from the university, academic researchers, scholars, R&D, and everywhere, and they are constantly required for the changes. Please go ahead. Please go ahead. Now, this is the most important criteria where all the patents are resting on. Whatever your claims, whatever your description, whatever you are claiming in the patent document, they are resting on these 4 or 5 aspects. One is new, novel, novelty in invention. What is this new, novel, and novelty in the invention? Is that the invention should be original in its nature, first of its kind in the world, not in the country or in the state or in the city, but in the world. Any new compound, new method of preparation of compound, production process of any compound, new use, utility also, new use, new composition, new analysis, new apparatus, new machine, all these are covered under the novelty, newness, or novel invention. The invention must be totally new, nothing, nobody knows it, even not published, not mouth published, or not known anybody. That is called totally new. This is one basic criteria of patent filing. If this criteria is lost, then the patent will not approved in toto. But there are other aspects which we have to consider. Though there is a novelty, newness, but there is no new, though there is no usefulness to the society. Such type of patents are also not approved. So usefulness, capable of industrial application, is another criteria where patents are granted. The invention must be workable, means somebody can do it. It is not so easy for doing, but a known person must know that how to prepare that, and the procedure that is explained in the patent is good, and that can be lead to the proper product or process. Capable industrial application, that can be useful also, it can be useful for the society also, and its useful is in general criteria also. So usefulness is another criteria where essential thing is more important. Okay, go ahead, please. Please. Then non-obviousness or not known, everything is there, newness is there, then your what we have seen before, newness is there, then usefulness is there, but I have told that today I have told I am doing invention on this and this, and I am just filing a patent. After my filing a patent, when it is published as a application accepted, then somebody attending from this meeting, they can say that this person on this date and this communication, he has explored that this patent is there, this will work like this, and I know the things. And that is why even if somebody raises such point, even if that patent will be not granted, but there are now certain specifications, certain rules, amendments are there where you can have certain period, 6 months or 1 year, in depending on the patent officer and all these things. So one thing is that it should be not known to anyone, it should not be published before. That is called no product or no process is known to anyone, and it is not published in any source of literature so far. And that is why we can won the Haldi patent, because all the documented text, though it was not openly available, but they were available in the holy books, whatever they have preserved at our country level. That is now TKDL and all these things, they are taking a very proper care. Then fourth essential point they have, apart from these three, fourth is that patentable subject matter. Say for example, one subject is can be patentable in India, but the same subject cannot be patentable in US. Some cannot be patented in Japan. Same cannot be patented in Japan, Chinese also. So such type of the patentable matter should cover in the patent law of that country also. This is another thing. Otherwise, they will not accept the patent, that we are not accepting this the patent which are coming under such and such areas. Okay, this is another step into that. Then one inventive step is there. So patent is known, product is known, process is known, everything is known, but some in it is more or less in chemical sciences, or some machineries, or something is there, engineering sciences, medical sciences, something is there that among the process I added certain element which boosted the matter. That is another thing. I just boosted the matter, so that its production is more, it's a new way of production, it's totally a different product coming out of that. So one of the inventive step, for that only, that for that step patent can be granted. So these are the five basics concepts or criteria on which patents are granted. And whenever we file the patent in the patent office, the patent officer, patent lawyer just assess these five conditions in toto, whether they are fixing into these five categories, and then he will explore for the further knowledge basis. He will read details of the things, and then he try to find out how, what are the claims, what is the procedure, etc., etc. But only one thing is there: full disclosure of invention must be patented and submitted to the patent office. This is very, very important aspect. Without that, otherwise, either patent office may reject, or after granting or after accepting the patent, some objection from the third parties will come, and that is very difficult to solve at that point. So, just please go ahead. Please go ahead. Now, what can be patented? As just now we have seen, any product, new inventive step, atom, or whatever may be, chemical, devices, drugs, pharmaceutical, any article, uh, design, everything, process or method, any process, machines, all these are protected. Okay, go ahead, please. Then what is not patentable also, yesterday madam has disclosed all the things, so I will not go in detail. But only one thing is, I will just summarize in brief, is that discoveries, principle, natural substances, scientific theories, then abstracts, ideas, these are theories, mathematical models, then algorithms, business methods, agriculture method, horticulture method, teaching method, learning method, nothing will be. They all will go to the copyright side. Even if you want to create a monopoly, you just copyright it, because copyright, as you know, when you create the document, automatically you will get the copyright ownership. On the special case, if you want to register the copyright, then you have to go to the copyright office and file the document. Then aesthetic creation, artistic work, all set of computer program. Earlier they were not coming under the patented thing, but now many countries are giving patents to the computer because they have a different algorithm, different steps to follow. Different programs are there, and their programs are very unique, and they are not disclosed very easily, like that. So these are the basic things we have just seen. Then benefits of patents are to the inventors are there, society is there, then patent agents are there. So everybody, every component of the society is benefited. Now, how they are benefited, I will tell you. Inventors, they can use the patented invention to develop the new product, new ideas, read more things, generate new concept, generate new ideas, and just file a patent and just licensing it to generate the income. Society in general, newer, better, cheaper products are available to the public. Say, for example, earlier I was using the Colgate toothpaste. Now, Colgate toothpaste, you will have a salt addition, then zigzag, and then that is, you can say that many things are coming, that crystals are there, and on this also there are patents filed on this thing, that on a single product you will find thousands of patents filed into that, or hundreds patents definitely be filed. Even if you have a blue toothpaste, after rubbing it, the color of the foam will be white. So all such type of things are patented, and these are the new activities or new things given to the society. Researcher, they can avoid the duplication. At the elementary period only, they can just skip away the whatever invented things are there, and they can work on the proper guidelines. Then consultant and planners, they are very prominent in this thing, and the main beneficiaries are consultant, planners, and patent agents. Why I am telling you these are the beneficiaries? Because patent agents are helping in filing the patent to you. Patent agents are so popular and so prominent that they are always reading patents. Say, for example, I am also a retired person, but I am keeping myself abreast of the knowledge of how we can just move around the IPR and patents, and what are the new things coming out. So similarly, like patent agents are doing, what is in the particular area they are interested, what is new coming, what are the new patents coming, what they are disclosing, what are the ideas they have disclosed, what claims are identified by them, how they are differing by them or not. If they are not differing, then they can sue the cases to the inventor, that this is already invented before, how you can put these claims into your patent. All such type of things patents are doing. And then patent agent have the visionary, they can just act as a consultant for the industries, for the researchers, or for the scholars, for the different organizations, R&D, scientific information, or scientific organizations, that this is the future trends in the patent filing. You can go, these are the gaps in patent, and you can file patent in this area, you can work in this area. So all these patent agents and consultants and planners, they are working on these things. And this patent agent or consultant main job is that if patent is very popular, and if it is not renewed at the proper time, then they can just use that patent and make the product, and nobody can sue you in the court of law. And this is called as window period. In the window period, you can use that patent without anything. Say, I have a patent, I have paid the fees for 5 years, then I thought that nobody is asking for that patent, so I have not renewed it. But after 1 year, my friend came and I have seen your patent filed, and just I have seen that that is very valuable. Why you are not renewed? Okay, I will renew it. Again, I will go and renew it. So during that 1 year period, if somebody has used my patent for the production purpose, I cannot sue him. This is the one more criteria for this patent agents and consultant and planner. They can just guide to the different industries and what is forthcoming. Then patent attorneys also become very helpful. They are benefited by this patent because they know that how what patents are going to file, which patents are filed so far, what are the guiding patent they are providing the guidelines for patent filing. So all such as patent attorney, then all these four blockages, that is patent agent, consultant, planners, these are the basic uh, elements which definitely help anyone to guide for the patent filing and just guiding for the proper direction toward the proper innovation. Then industries and organization are also benefiting because they will get the improved product. They will find out new inventors in the system. They will replace their old systems. Whatever may be there, industries and organizations, they are very well benefited by this. Then go ahead, please. Structure of patent, as I told you, it is very important. Why it is important? Because it has a standard level. If you see that patent title page, you will find title of the invention, abstract is given, background summary is given why that person in the background he has given what he has done, what was earlier, and what forced me to conduct this research. Then drawings and diagrams, detailed descriptions, all these things are there. Then claims are more important parts. If your claims are turned down, your patents will be lapsed. So while writing the claims, you should be very specific, legal, to the point, and what you are going to do and what you have solved and what is your problem, what is your solution in the way of claims, it is described. Then declaration and oath and IPC code is also there. IPC code is very important. It is a group of classification code like colon, DDC, UDC. International patent classification is there. In fact, I will tell you that international patent classification is more deeper than any other classification, and that is why, along with the keywords, if you add IPC to the searching element, then you will get very prominent patents, and that is very good for you to study further. Then patent application number and date, and patent granting grant number and date. Some spelling mistake is there, uh, but it is a patent grant number, and these are there. These are the four essential things what we have to look into, and all the patent things are giving. So when we come to the patent filing process, we will see that patent filing is very tedious that way. As what we have seen the many examples. Can you go to the next slide, please? As we have seen that patent filing process is very difficult process. It is very studying process. You should go step by step into that. So if can you go ahead, please? Please, huh? Go ahead. Go ahead. Go ahead. Huh. Now, in India, the patent filing process, what we have seen is that inventor can file the patent many ways. But in India, we have made two, three aspects into that. One is that a provisional specification, as we seen before, can be filed, and within 12 months, we have to file the complete specification. What is the benefit of the provisional specification? That is, you will get the priority claim. Within 12 months, whenever you file the patent, your priority date will be as of today. That is one thing. And here you cannot mention the claims. There is no need to mention the claim. you can file the general description, common description, whatever you want to disclose, you can file. This will bridge a compound wall for your invention and confirm your date of priority. Then after 12 months, you have to file the complete specification along with the Form 1 in Indian Patent Office. And this complete specification will be a full described patent covering all the items what we have seen under the structure of the patent. That is most important. And in India, there are four offices that we have seen yesterday. That is Mumbai, and they have a jurisdiction also. Delhi jurisdiction, Chennai jurisdiction, Kolkata jurisdiction, and only online things you can file online filing portal. You go and file online first, but physical patent you have to file into the particular jurisdiction. So that is the one thing for Maharashtra, as yesterday Madam told, that Mumbai Patent Office is the main. Delhi is the headquarter of the Calcutta is the headquarter, now where you can just correspond everything. Okay. So these are the patent filing. Now we will go further and look into the patent filing process uh, in short. Say first of all, before filing a patent, or rather, I will say that before. Can you just move the slide, please? Okay. So patentability search. Initially, what happens when we are just starting the process, patent filing process, little bit very complex, but not that complex if you are subject expert. That is one thing. Now, patentability search. What is this patentability search? It gives you prior art and novelty. This is one thing. This can be done at two stages. When you start the work, that time also you have to file, search the patent databases, and at the time of filing your final complete specification, that time also you have to search the patent databases, and this is called as patentability search. This patentability search gives you two benefits. One is that it will prove your inventive step, or your novelty step, newness step, and usefulness step, and you are not crossing the limits and entering others' domain. Whatever patents are filed, you are not copying them. This is one thing. So initially, whatever process starts from the start of the project, or start of the invention, or start of the uh, searching patent, whether we can work on this area or not. Determine patentability. Before initiating, we have to conduct this. There are many patent databases available free of charge. All the patent databases are open patent databases that can be used by anyone. On the most you can just need to just register your name, password, and user ID. That is the only thing, but you can use free of charge, except commercial patent databases. Commercial patent databases are chargeable, and that you can use at the time of final filing of the patent. That is the difference between these two. So USPTO has a very good databases. INPADOC International databases is there. WIPO, World Intellectual Property Organization database is there. European Patent Organization (EPO) databases are there. Apart from that, Google Patents are there. You can search on Google Patents also. You can search almost all patent databases, but USPTO and INPADOC and Google Patents, as well as WIPO also, you can work almost all. Many things working on that issue. So you use these databases at the preliminary level, then construct your strong idea which can be patentable and work on that area. But one thing we have to find out that we have to fix four criteria, that novelty must be there, non-obvious must be there, and it must be useful to the society also. These are the things we have to monitor. Okay. Then third point of this patent filing process is that complete experimental work and start to prepare the patent application. In the meantime, after finishing these first two steps, after finishing all these things, the things will come as a finish your experimental work, repeat many times that experimental work. Please continue the slide, next slide. I think who is, I'm sorry, who is managing this slide? Just keep watch on that. I'm just giving sign only. Yeah? Sorry. Complete experimental work you have to do. You have to repeat the experiment so that your results are constant and you can be fixed with the solution. That is one thing. Then start preparing patent application drafting. So these are the things. So while writing or while writing the application, title of the invention, you must be very, very specific into that. Your abstract summary of the invention must be just 500 to 1000 words. Background of the information, what was the background and why I taken this project and why is my research essential or why my invention is essential, that is under the uh, background. Explain current method what you are given. These are the things. Then detailed description is covered everything. Initially, what are the previously published literature and what they said into it, that you have to narrate the summary. Okay. Then you have to discuss based on this thing. I understand this new, or I just gain new knowledge or new idea which I am working, and I want to file some, or I want to discover some new solution for this problem, and that is the complete description is there. That is step by step. It should be exact to the point in simple way, but legality should be there. Then step by step wording, then logical, technical, and architecturally perfect. Your document, it should be well documented. There should not be any ambiguity. When you are reading, anybody should see that it can be accepted for patenting or patent granting. That should be like that only. You should not just poorly cite your detailed invention. It should be very properly cited. Claims define the scope of the product protection. What I was considered, what I am protecting, the main claim, parent claim that is called as, and subordinate claims or independent claim or dependent claim. These are the different terminologies used in different countries, but meaning is same. Parent claim, child claim, independent claim, dependent claim, main claim, subordinate claim, whatever may be. But your main claim is the basic claim on which your patent is granted. Subordinate claims or following claims or child claims or dependent claims, one or two may be repeated, that can be removed, but the patent can be granted. But main claim, if it is not satisfied, then patent will not be accepted. That's why claim part is a very, very important document in the patent drafting itself. I'm just giving you the general overview as if we should know what is the document covered into that, so we can guide the users, inventors, researchers, scholars, academicians properly. Then oath of declaration and all these things, inventor can first file provisional and everything. So go to the fourth step. That fourth step is that, please go ahead, select the right type of patent. This is very important because we have seen that there are different types of patent. that is utility patent related to product and process, then design patent for the design, architecture, aesthetic, filing and all these things, then patent, plant patent related to the new plant varieties and all these things. Then when you select the patent type, then you have to convert your description accordingly. Then if a design patent is there, more design work will be there. If your process patent is there, more flowcharts will be there, product patent will be there. So based on the type of patent, your detailed invention or detailed description will suitably reformatted. Then draft the application, either provisional or complete. As I told you, provisional no claims are required, but complete should be complete in all respect. Okay. Then submit the application. This is draft application. Form 1 and Form 2 are necessary. With Form 1 provisional, Form 2 complete. Then submit application to Indian Patent Office either online or physically. You can, and there are different fee structures are also given, that between 1600 to 20,000. But in general, if you file your own patent, then your cost will be reduced. But everybody is not a patent lawyer or patent understanding person. Hence, you have to take the help of patent attorney or patent guiders or patent filers or patent, you can say patent attorney, patent lawyer, whatever you can connote, but it is just patent agent is the proper term they have used many where. So we can say we can appoint the agent and we have to pay the agent's fee. There are many approved patent agents by the Indian Patent Office or every patent office in the world, that they will take care of the things. So the patent fee will depend on the country to country and where you want to file the patents, and based on that it will be there. But not more less than 2 to 3 lakhs. We can assume approximately that much cost will be there. Then please move to the next slide. Then submit other required forms also, form 3, 5. These different forms are there. Say for example, for form 3, which is the statement, form 3, which deals with the statement and undertaking for the foreign filing. Because at the same time, if you are doing national filing and you want to file for the international, you form along with form 1, 2, you have to fill up form 3 also, so that the patent office will also know that within some stipulated period you have to go for the international filing also. Then form 5 is also there, which will inventorship will be declaration, who is the main inventor and who are the subordinate inventor, who is the assignee, who is helping them to file the patent, and all these things that will be fixed in the form 5. So these forms are very essential on that point of view. Please go ahead for the next slide, please. I think okay, please continue slide. Then publication and patent journal. Say after generally 18 months after the filing the patent, it is announced in the patent journal, that is Gazette of India, section 3, part 3, means accepted patent application. Under that, some bibliographic details are given, and you have to just get announced that everybody in public, it will be announced that a patent is going to be accepted for publication in few years after detailed examination by the patent office, and this is the summary of that patent, or this is the bibliographic detail of the patent. If someone has noticed that same patent I have filed and granted to me, then he can also claim for that I have a patent of the same nature, that we will see in the next thing. So your application automatically gets published after 18 months in the Gazette, and inventor also, you have to option to request for the early publication. They have to pay certain fees for that, and early publication for that they have to go ahead. Then here, after just publication in the gazette, then you have to request for the examination. For the patent office, you have to request that you should now examine my patent for the further procedure, and it should be filed within 48 months of the priority date. When you file the complete specification or provisional specification, from that date, within 48 months, you can just uh, ask patent office. Form 18 will be filled, and within 18 months, with a prescribed fee, you can ask the patent office to examine my patent. Without that, they will not examine it. This is the most important step into that. Please go ahead, please. Examination and office action. After taking the patent, after your examination and everything, patent office look into your patent. They will study it properly. They will search the databases, whatever databases available in the market, not free of charge. They will go for the commercial databases, because commercial databases, the difference between free and commercial is that commercial databases are properly structured, whereas though open source databases or open databases are accessed freely, they may be structured, but they don't have that access points which commercial databases have. For example, chemical patents, I want to search, I can search by chemical abstract or registry number, which is not available elsewhere. It is available only chemical abstract databases and all these things. So such type of things are more essential, and that's why, and this will reduce your burden of searching also, and pinpointed searching elements will be there. Furthermore, there are many databases, commercial databases, which are working only on claim side. What are the claims? The claims, as soon as you put your claim in your patent, that patent can be just searched in the patent databases where claims are there. Then uh, then the immediate how many patents have been covered, so same claim will be displayed on the screen. So this is very good for the patent lawyers who are sitting and inspecting patent application in the patent office. And here they are giving the first examination report to you. If there are certain lacunas in the application, or certain things are overwritten, or something are underwritten, or something is missing, something is duplicated, somebody has already cited that in their previous patents, all such type of thing in the first examination report, patent office reported to the inventor. Then inventor has to work on this issue, and they have to satisfy the queries raised by the patent office. And if patent office satisfied on the replies received from the inventor, then patent is granted for the 20 years. And again, these granted patents are published in the Gazette of India, section 3, part 3. Then every year you have to pay the maintenance fee, or lump sum you can also pay the maintenance fee. Without paying the maintenance fee, you cannot keep your patent active. This is very important thing. Then there are post grant events also. After granting patents also, somebody raised the objection that I have missed this reading, but this is the copy of my patent, or some claim or something. So post grant event, some opposition third party may claim something, and that the inventor has to reply. So before filing the patent, application must prepare draft document of the invention very, very thoroughly and scrupulously. Avoid public disclosure. Means you should not disclose it to the common public before filing. Use non-disclosure agreement. I have not disclosed, you have to mention it. If discussing invention with others, If you have discussed, then non-disclosure agreement you have to file. If drafting is not possible for inventor himself, then he can hire a registered patent agent or attorney, whosoever may be, for drafting and filing the invention, which is more easier for them, though it is costlier affair. But your patent rejection chances are rare in such cases. This much we can assure for that. Then timeline, just please go ahead for the next slide. Timeline grant. Generally, patent takes 3 to 4 years for granting. The process start actually after the 18 months when you are asking for the examination. Then patent offices give you first examination report, and after examination report, within 1 to 1.5 period, you have to just everything, after paying everything, you will, within 1 and 1.5 hours years, you can just get the patent granted if everything goes well. So to keep the patent valid in India, annual renewal is essential. That this is the timeline. Means generally you take it granted that 1 to 4 years period span we have to give for the filing to the granting patent. Now, where to file the application? There are, as please go next slide. Inventor can file two ways. One is national filing, that is, you go to the USPTO, that is United States Patent Trademark Office, USA, or Indian Patent Office, India, or European Patent Office, Europe, Japanese Patent Office, Japan. Wherever you want to file, you can go. Inventor can go and file application directly to each country also. As per the Paris Convention, within 12 months of the first national application, you can file anywhere. But initially, mother country filing is most essential. That is national filing, and then, but in national filing, PCT route following is not essential, and this is a separate application form, and country specific translation and other separate legal procedural charges you have to bear separately. What is the benefit of going through the PCT convention, that is Patent Cooperation Treaty? What Patent Cooperation Treaty is doing is that Patent Cooperation Treaty get your application, they examine it, and after examining, they are giving you ISR, that is Information Search Report, whether your patent or your application filed is patented properly. It has a right to patent. It has a right to declare as a patent. This certification is given by the Patent Cooperative Treaty, and based on this certification, you can just apply in any of the country which are the member of the PCT. India is also a member of PCT, and almost all countries, that is more than 130 countries, are member of the PCT. So this is the another route. Why PCT route is economical or cheaper? Because your information, that is invention search report, is already ready with you, so that the patent filing country need not worry about your patentability acceptance. Only they have to file the whether our law is accepting that patent, and whether the things are properly as per their own language. Suppose you want to file in German, the patent should be in German language. If you want to file in a China, that should be in Chinese language. If you want to file in a Japanese language, Japanese country, it should be in Japanese. Whatever the mother language of that country is there, in that language you have to submit the patent, and this translation cost will be reduced for the purposeful, and it will give you the family tree also wherever this patent is granted to them. So this is one thing. Then fee structure, as I have disclosed to you earlier also. Documents required, please go ahead. Documents required, as I told you, Form 1 along with the grant of application for the grant of patent, then provisional or complete specification, that will be Form 2, Then Form 2 statement of undertaking will be there. Then Form 5 declaration of inventorship that I have told you. Then Form 9 request for early publication. If you want to speed up the matter, you have to pay the additional fees, and along with Form 9 you have to request it. Then Form 18 request for the examination, because after request of the examination, IPO or any patent office will take care of the examination of patent. Then if you want to give power of attorney for legal activities, then Form 26 will be filed. Then Form 27 statement of commercial working will be there. If you want to just file after patent is granted, to disclose whether invention is being commercially worked out in India and all these things. For that purpose, you have to because you will go for commercialization of your invention. Then Form 27 is required. Declaration of startup or small entities, because priorities are given for such entities like government bodies are there, women entrepreneurs are there, small startup agencies are there. Somebody has asked yesterday's questions also. So for them, if you declare them, then your fees will be narrowed down or reduced down, and your processing of patents will be much more faster. Please go ahead, please. Now, as a case of matter, a sample patent draft, how it is there, I am just taking the tidbit of that. It is not exactly the same, but it will follow certain guidelines for you. We are not going to file a patent, but how patents are filed legally, logically, that is given here. So first of all, title. Whatever sample draft, when you started your writing draft, patent draft, then what you have to take care? Title. Say, for example, I have taken two titles: Smart Library Book Return and Notification System, a smart water bottle with temperature monitoring and reminder system. One is from our side, one is from common side. Now, next step will come. Applicants' names will be there. Assignee names will be there, if any. Generally, assignee is your organization, institute. Inventors are applicants. Then, or even assignee may be also applicant. The case may vary. Then, nationality. Here, clearly define your invention by thinking on what problem does your invention solve. Wherever, when you draft the application or wherever you draft the patent application, you should be very clear in your mind that why I am doing this invention, what is newness into this, and how my solution, how my given solution will work very positively on the problem. So, and what type of instrument you are using for that. That may be a method, a device, machinery, or software, whatever it may be. This must be clearly mentioned into this. Now we will come to the field of invention. We'll take one example. The present invention relate to the smart library management system. Why I am doing this? Because manual system takes more time for the issue return system, and that's why I am configuring this new model for the patent filing. Background of the information. So the present information related to smart library management system, and whatever things are there, this system will help automatic return, issue a reminder, then checklist, and all whatever may be there, that may be disclosed. Then background of it, the information is that why I am conducting this, because manual work is tedious, complicated, it will take time, and it will be a laborious work, and the time saved by the providing this service, by automating it, the manpower will be utilized for the other purpose. Such type of things, background innovation and all these things will be given. Then you have to summarize your invention in brief. That is summary of the invention. The invention discloses smart return of the kiosks, Means whatever the description is giving, kiosk equipped with RFID sensor and the wireless communication model. When a book tagged with a RFID chip, it is dropped into the return slot. Then the return slot accepts the book. It will scanner will automatically scan the RFID strip, and it will just read the accession number. It will search to whom it is issued, and it will get cancelled, and notification will be given to the mobile of the user automatically, so that he will be satisfied that my book is returned to that. This is the summary of the invention they have given. Okay. Similarly, also for the another invention, the invention provides smart water bottle comprising of thermistor based temperature sensor. When the water cooling is less, then it will giving that your water is cooling down, its temperature is going low or its temperature is increasing. Furthermore, if you are dehydrated, your digital watch give you indication that it is a time for you to take a lump of water, like this. So all such automatic things are coming into the objects of the invention, or the basic summary of the invention. Then objects of the invention, the main object of the invention is proper circulation. It is especially a return of the book through the kiosk method, and it should be intimated to the user on its mobile or its smartwatch, whatever it may be. Then brief description of the drawing is also given. In case of one, block diagram of the smart book return system is given. Then workflow of the diagram, how it will happen, how book will come. Means such type of brief description are given. So please go ahead. Detailed description of the invention covers detailed working of the procedure. The smart library book return system covers a return slot module, RFID scanner, then your micro controller unit, then Wi-Fi unit, cloud data interface, notification module. All such type of thing one by one will be given. And this invention reduce manual workload, improves user experience, and ensure real-time updates. These are the your detailed description will cover into that. So all such type of things are just covered into the detail. Then another thing will be, please go ahead. As another thing will be claim part. Claim part, as I told you, that claim part should be very complicated, very precisely mentioned, and all your things will depend on the depend on. Please go ahead on the claim side. An automated book return system comprises of a return slot, RFID sensor, microcontroller unit. This is one claim, but in the dependent claim, the system of claim 1, wherein RFID sensor is configured to detect the presence of book when dropped through the return slot. So this is the clear claim we have put. Similarly, 4 5 claims are given. See, even as another example, we have taken a smart water bottle comprising temperature sensor configured to detect the temperature of the liquid. Microcontroller configure the process data from sensor. Bluetooth communication module will communicate the data to the user. Real-time clock module will communicate timing reminders to the user. Like this, they will form the claim, main claim. Main claim is smart water bottle comprise this. And the second claim, the smart water bottle, as claimed in claim number 1, wherein temperature sensor is thermostator. What it contains, that is given. So similarly, for any invention, you are deciding your objects, your detailed description, your solution, and what you are claiming, main claim, and then in the main claim, what is covered in is described in the subordinate claim. That is main thing. Okay, please go to the next slide. Then abstract. All the abstracts are given in short that publish always in the Gazette or whosoever have a patent databases. The abstract is copied from this to databases. Then there are many optional sections are there: drawing, sequence listing, tables, computer programs, and they are many things are added as appendix also. And see, for example, after the draft, you can amend all these things. Forms also, form 1, form 2 we have seen, and we have seen the filing process also. Okay, now we will go to the somehow of the other side, drafting patent claims. See, as I told you, no, patent claim is very, very important. You cannot neglect the patent claims. So please go ahead, 2 slides ahead. Drafting patent claim is most crucial or critical, and it is a technical part of the patent. See, it is a completely technical part. You cannot mislead. Claim define your legal boundaries, what you are protecting. That is, legal boundaries are covered. Then poorly drafted claims. If you poorly say, okay, I will just go and file it, it will not work. It will be rejected. Your claim should be, you have to study it very well. How to write a claim? What is main claim? What is dependent claim? You have to study very, very well, scrupulously, because the patent writer, inventor reads lot of patent literature, and then he understand how to write the all these things, how to draft the patents and all these things. And that is why there are examination courses for patent lawyers and patent attorneys. All over the world they are there. In India also 6 7 agencies they run, including CSIR and URDIP and your Hyderabad Nalsar University is there, and now many universities and law universities had added as a patent law syllabus in their structure of syllabi and curriculum. So all such type of things are coming. So drafting patent is very essential. Understand the purpose of the claim, why you are putting this claim, that you have to understand. Claim answer to the question like what exactly you are trying to protect. What you are trying to protect. If you forget about protecting the main thing, then it will be lapsed automatically. So, from legal definition of your invention, when granted your patent, only what is covered in the claim is protected. Your patent granted or protected or given grant means your claims are protected for that invention. That is in simple logistic thing. Now, independent claim, dependent claim. Independent claim is standalone claim, and dependent claims are some other specific claims which are improving on the independent claim, or they are just giving minor things to it. So within just 5 10 minutes, I will just sum up the things. But this drafting claims, there are different formats are there. That format you have to look into that. Broad claims. Remember that broad claims are very, they will serve, no doubt. Broad claims likely to be rejected or challenged. That is very important thing. If you not carefully draft it, then in the future after grant or after application, they will be challenged to you, and that is very difficult. And too narrow claim, easy to design around. If you narrow down the claim, then you can easily narrow down your proper working and functioning. So your claim must be novel. Claim should be new, novel, non-obvious over the prior art. They should not file somewhere. That is why there are certain databases which are basically available for patent claims only. Okay, this is one thing. Then please go. Add dependent claims as per your thing. You can go and add the dependent claim also. We will just and number the claims very properly. Each dependent claim should be refer back to the previous claim. What you want to correlate your dependent claim with the main claim also. That is more essential. Patent process, you are just as I told you that waiting period is nearly takes some months initially, but it takes 1 to 4 years minimum. At least after 2 years only they are granted. But now the policy started that patent application itself is published, like Japanese patent office, US patent office. If they are rejected, forget about it. The patent will not be granted. That is one of the things. Now another systems are, and these are called the revisions coming under the patent laws and patent act. Then patent office actions is called as first examination report. After that patent examination report, we have to reply back to the patent office. So this we will now. PCT route filing we have checked. Please go ahead for a few more slides. But PCT cost you, go ahead, please. Please go. Please continue. Continue. Uh, just go ahead. Just go ahead. This I have told you already in short. Go ahead. Just just go ahead. Uh, Advantage I have told you what is what are. Go ahead, please. Only last slide. This. The PCT cost overview, generally it costs $14,000 onwards. But in general, PCT filing will cost you 15 to 50 lakhs rupees. But you can file it in many countries and you can establish your monopoly in different countries also. Okay, go ahead. Now, rights after filing the patent are also there, and rights after patent granting are also there. After filing, what you can say that patent pending. Many times you see that patent pending, trademark pending, or design patent pending, or they give application number. Means the process, thinking of the invention is in process, so it will gear up the market into that. So this is the basic advantage of the after the application filed, and after the patent grant you will get the exclusive right. Please go ahead. Exclusive right to use the patent, sell the patent, then you can license the patent, then right of monetizing the patent, license or sale or patent. All these things you will get automatically, and you will get also right to sue for infringement also. If somebody uses your patent and you detected it, you can sue him in the court, and whatever loss is bared by you, that will be compensated by the court. These are the different benefits you will get after the patent is granted. Okay, right to transfer or assign a patent holder and all these things. You can transfer the rights also by will also. Then post patent filing process, we have seen that after post patent filing process, if you have another queries coming out from the patent office. Okay, go ahead. Go ahead. Just go ahead, please. Yeah. So one thing we will check into this. Uh, okay, I think this is much more detail. Pre-grant opposition, post-grant means opposition is of two types. After application, your opponents will apply for the rejection, or post grant opposition also, after publication also they do. Pre-application or pre-grant opposition, patent office can communicate with you and there is no need of personal meeting at patent office. But after post grant patent, you have to justify what others are saying about the patent claims or patent what you have copied into that, and that is why sometimes you have to appoint patent lawyer for pleading your cases also. These are the post and pro. There are some patent rules and all these things. The patent information searching is the prime area of librarian information science professionals. There are various types of patent searches. And these are very unique patent searches. Without patent searching, you cannot start your process itself, I will say like that. Why I was working in NCL for this patent unit? Because of this patent searching only. I search patent using 300 databases spread all over the world, and then give the solution to the users or patent innovators, or whatever they have filed the patents, or what the patent, I was just correcting in them, or I was just suggesting them that if you turn to this, then your claim will be approved, and also and so, that I was just telling them. Okay, so if you see there are, just please go ahead. Please go. Just one more. One more. Okay. 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 Go ahead. Okay. Go ahead. Okay. Now there are good patent access points also. Basically, you can work on subject. You can basically subject, that is trivial searching. I always read patents on my field. What our professionals are filing in patent application, you can definitely add into that. Then keywords, of course, everybody, but patent classification is unique classification. You can search by that. Then inventor and assignee, that is more important. Here, chemical structure, this chemical structure and all these things, that is also essential. You can work on that. Then chemical substance is there. Then structure searching is also there in chemistry. There are very, very special things are also there. These are the access points for that. You can search. There are many databases. Please go ahead. There are many databases available, like InPad, Derwent, I told you. There, but there are many commercial databases you can search while filing the patent. Just go ahead, please. Go ahead, please. Go ahead. These are some patent sites I have narrated. These are the free patent sites. You can you go and just apply them. You search on any topic of your interest, you will get lot of patents in your list. Type of patent information searches. Prior art search is more important. Patentability search is important, that we have seen. Why these are conducted? For maintaining your inventorship or invention to the track. Freedom to operate, the state of art report, what is the present status of that invention. Okay. Then invalidity or opposition search. Go ahead, please. Go ahead. No, go ahead. Okay, leave it now. Then invalidity or opposition search. Suppose somebody opposition you, then you have to again search for the databases. That is called opposition search. Patent landscape analysis. You can get the landscape of patents, where you can find the pitfalls, where to go and file the patent, which is the saturated area. If legal status shows that patent is debarred, patent is not useful, patent is not renewed, you are free to use it. And after 20 years, patent will come to the public domain, then you can freely use it. And many R&D holders, they are doing the same thing. They are waiting till end of the 20 years, and best patent will start working on that. This is the jugglery of the patent filing. Then skills required for patent filing is that you must be technically expertise. Your technical expertise is more important. In case of searching patents and all these things, your legal knowledge should be at least not perfect, but should have a legal knowledge. Patent drafting skill also essential. If you are not a patent drafter, then hire patent attorney or patent lawyer. Research and analytical skill are essential, where you can analyze your patent and present it properly. Then prior art searching is very essential, where you can just search your prior art and work on that. communication and collaboration skill, where to collaborate, where to communicate, how to work in collaboration, how invention can be spread. That skill is essential. Time and project management skill is very essential, because this is a time bound project. Within this stipulated period, you have to do this activity. Within this stipulated activity, you have to file the forms and your documents. You have to reply to the queries in particular stipulated time. Lot many things are there. It is not so easy to just grab everything in one session, but I have given you a broad, narrower picture of the patent filing process, patent intricacies, patent criteria. Then how to avoid the pitfalls. Go ahead, please. Common pitfalls to avoid while drafting the patent document is also an important aspect. Purely drafted claim, inadequate description, over disclosure of priority. Means don't go beyond, or don't go less. You should be in moderate level of the drafting. So these are the different activities they are saying. So there are many patents. If you just please go ahead, you just slide down the 5 6 PPTs. There are many examples of patents in library science also, as well as common patents are also there. And you can see that some patents filed, like a common patent, I will tell you: method and apparatus for advertising on a mobile gaming devices. When you play the mobiles, or when you look into the your internet, you pop up some advertise and all these things. So all these, while gaming also some advertises came. So for this also patent is filed. Sport devices patent is filed. Sport rackets and racket handles, there are separate patents. Means there is no specific area where you can file only patents. There is abundant area, abundant knowledge where you can file the patent. Only thing is that generation or creation of nascent ideas from the mind and brain of a human is an essential aspect, and it comes from the experience, knowledge base, and continuously working in that field. And just reading lot of literature in your topic, it will galvanize the things for developing new ideas, and new ideas will inculcate in patent drafting, patent filing, patent granting, etc. These are the total overview of the patent filing and all these things. In a nutshell, I have reduced so much. Only thing is that we have a just slide or display and the PPT presentation some problem. That's why we could not correlate properly. But I tried to explain at maximum level, at my level best. So thank you very much for giving me a chance. I really thank you, each and everyone from this dais. Especially thanks to Dr. Katimani, then Viresh, Milind, Sambhaji, Dr. Khobra Gade. Especially, I am very thankful to Dr. Prasad and especially Pradeep Rai, who initiated this activity and just brought all the professionals under one umbrella. And then you are just mixing up with the people who are working in different areas, and you are developing awareness of patents and IPRs and patent filing. It is really a tedious job, but at least we have got awareness. What are the intricacies coming in between, and why patents are not granted, or patent filing is not so simple. So thank you very much. I wish you all the best for this. Thanks. Any issues, any problems, any questions, you can ask me. No problem.
Thank you, sir.
Thank you, sir.
Thank you. And we don't want to continue question answer session now, because we would like to give some relief for you, because you are continuously speaking. And
No, that is not a problem for me. Only thing is that this technology, that is a little bit difficult sometimes for me.
No, sir.
Because I have just shifted my PCs. No,
Sir,
otherwise.
you are much ahead than us.
No.
Many ways that we
Yeah.
know.
Thank
So
you.
not like that. And is Pradeep available online? Pradeep ji? Okay,
Yes,
sir.
I think so. Online.
Okay, we will
Yes, sir.
continue.
Okay.
Is Pradeep ji available online? No, seems.
Yes, sir. Yes, sir.
Sir, I would like to have
Sir,
from
namaste.
ILA president, sir.
Namaste, sir.
Then we'll
Namaste.
have a question answer session so that you also get a brief, some brief and all. Okay. Let us have
Okay.
some small. I request Pradeep ji to say a few words about uh, your
Namaskar to all of you,
ILA.
especially Dr. N.B. Dahibateji. You have spared your valuable time and you have nicely elaborated the all aspects of from drafting to creation or assigning the patents. Definitely, this is very not an simple topic, but you have elaborated very nicely by giving the examples. And I think there is no problem through the slides because you are having very good experience in this area and you have elaborated very nicely. I think the professionals in the country aware about your capability and whatever you told, definitely the new entrants will be attracted and have a guideline from your end how to create, what type of topics we can go ahead, how to create, how to draft, how to take help, all these things. So, sir, once again, I thank you very much for sparing your valuable time and also thankful to the team for taking care of all these things to send to the LIS professionals. And again, as earlier I am saying, we will get more and more inputs from the participants. So thank
Thank
you
you.
each and everyone. Thank you.
Thank you, sir. Thank you for nice word. Thanks.
Thank you, Pradeep ji.
Yeah.
Sir, thank you. In fact, it looks like 6 words, a 6 letter word, but it needs 6 decades to understand. That much depth is there in this thing. Even we did
Yeah.
not know that there is a long and lengthy process involved in this thing. Because I am from University of Hyderabad, we have a couple of veterans from life science department.
Yeah. Yeah. Yeah.
They are always with good spirit. Our faculty keep trying for multiple patents. So we thank you for your insightful and engaging thoughts, sir, on patent filing. You are well explained the complex concepts of IPR and patent system. Your expert guidance have enriched our understanding and motivated us learn about parent procedure. Sir, you have covered many areas, which includes types of IP, background of IP related laws and conventions. What is the how conventions evolved? Paris Convention, Berne Convention. What is patent and overview of about patents, types of patents, criteria for patenting. What is not patentable? Benefits of patents and to the inventors, society, researchers, and patent agents, consultants. You have covered many areas, many things. The structure of a patent, how to file the patent, and what are the jurisdictions available in the country, patent filing process in India, different jurisdictions, and fee structure, documents needed, various forms required at various stages for filing patents in different situations, and then drafting of parent patent claims. Many things we have covered, sir. Rights of the inventors after patents. Also, you have told us few access points for searching and how metadata works, for how to metadata give for the metadata work and the searching the patents. So pitfalls, examples. It's really elaborative and enriching session, sir. We are very thankful. We are grateful to you, and we don't know whether we are able to hear such kind of lessons in the future too, because that is a very difficult, because you worked with a CSR lab, you may be having much awareness about patent system. Otherwise, normally the social science people and some other humanities is very tough. That much I'm sure. So I'm very thankful to you, and on behalf of ILA, I once again thank and congratulate you, sir. And stay happy, stay healthy, stay blessed. Now
Thank
we
you. Thank you.
request.
But I have read some questions raised
Yes,
in
yes,
the chat.
yes, yes,
So
yes.
can we go one by
Yes,
one?
sir.
That is
Yes,
not
sir.
a
We are
problem.
going to
It is
ahead
good.
for the
See,
session.
one Dilip
Yeah.
Jangel,
Yes, sir.
how does the publication of patent application impact rights of inventor and potential competitors in the market? We have discussed this actually. When you file and grant the patent, then the inventor or creator, owner of the patent, has a full right to use the patent either for his own benefit or for the society's benefit. He can license the patent to others by drafting MOU between them, and whatever consultancy fee or royalty discussed among them, that can be paid to the inventor. Basically, patent is such an instrument which gives you economic benefit as compared to others. As I told you, if you take the trademark, then trademark will give the prosperity of trading elements like market goods, market services, etc. So there is a definitely impact on the on the inventor by granting the patent by the patent officers. He Many industries interested in that product, they will come and hunt the inventor and sign the MOU with him for the developing new products. This is one question. How does the publication of a patent application
Same
impact
question.
rights of inventor and potential? Okay, same one above. Why is patent renewal and maintenance equally important as the initial filing, and what happens if it is ignored? Very good question asked. But one thing is there, I have explained this. But one thing is there, if you won't renew the patent, there are chances of misusing your patent. You are losing, as I told you, there is a window period. If you don't renew it, somebody else will use it. One term is used, that is patent watcher. There are patent watcher like bird watchers in the environment. These patent watchers, they watch when the patent is disappearing or when the patent is not renewed by the inventor, then they are free to use it. It is just like a open public document. That is why renewal of the patent is important one. Don't think that your patent may be important to anyone, but if your small mistake will lead to a major chaos. Okay, then third is why patent renewal. Okay, then what are the key stages involved in the patent filing process, and why is it necessary for inventor to carefully follow each step? I have discussed complete patent process. Patent process starts from the developing new idea till granting patent. After granting, post patent remarks also, or post patent opponents also. So you have to completely monitor this process. The key stages, as I told you, start the process, be very systematic, which type of patent you want to file, what are the timeline required for that, check for the novelty, non-obviousness, inventive step, patentability under the law, and usability of it. These are the essential stages. If you abide to them, your process is very simple. Write the patent in systematic way, legal matter way, structured matter, structured, disciplined content should be there, and all such processes complete. Then I have given you list of forms. You append the documents along with that form and fees to the patent office, and after granting patent, you can be patent holder or right owner holder of the patent or intellectual property. What strategies can be inventor adopt to commercialize their patent effectively after filing? Yes, after filing, one thing is there, one NRDC agency is there where you can register your patent for the exploitation in the commercial way. As soon as your patent grant is declared in the Gazette of Patent, then automatically those people who are watching, who are interested in that area, they will look into that and they will approach you. This is a very good revenue earning opportunity for you. Another way is that as long as you are filing in a single country, your single rights are there, but generally whose patents are very strong, they file all their patents in US patent, because US patent is a market hub. Whenever you want to file a patent, definitely after mother country you can file in USA, because this is the major big hub. Everybody will look into the technology developed by the US or US element. So they should not copy our patent or our product, so you can file your patent at the US also. Then another thing is that you have to follow the process of PCT filing if you want to multiple file the patents. That advantages I told you, that is more essential. Now, next question that was asked, looking at the real case examples, how can patent protect, encourage innovation and entrepreneurship in India? Now, this is very good question, no doubt, but it has long way to go. Now, Times of India and Hindustan Times, they suggested that the patent courses or patent awareness system should start at schooling level only. The reason is that the schooling boy, they have lot of inertia, and they can develop new and new nascent ideas. And if you inculcate their habit of generating new ideas by giving them awareness of patent filing or IPR, that is seven parts of IPR, then they definitely can develop new products, and new products will generate new avenues in the market. So, okay, this is the innovation and entrepreneurship in India. So, not only in India, you can spread up your novelty in other countries also. What are the financial implications of filing and maintaining a patent, and should investor plan for a long-term cost? Definitely, this depend on the inventor actually. Of course, whenever you try to file the patent, in financial aspects are there, and that is why what happens many times you find that independent inventors are filing their patents, but those who cannot pay the lump sum huge amount to the patent office, or for the breakup of the patent fees and all these things, they can go to the assignee. Assignee may be any institute, organization who can support their funding to them. And they may have assignee as their name, but inventor as your name. So that is just like a combination of both. I am benefited, you are also benefited. Joint collaboration will make joint efforts more fruitful. Like this financial aspects are matched in this activity. So anything more you can ask. There is no time bar for that. Okay. Now one more question. Nowadays we observe that many librarians and teachers are getting patents, and looks competitively easier than publishing a paper in reputed journal. Yes, it is everybody's own assumption. See, if you are feeling that patent filing is quite simpler, you go for that, because patent filing will. This is our Datta Kalbande. So thank you, Datta, asking for such a nice thing. And again, you will get good monopoly of filing a patent, and there are many occasions and many operations where we can file in LIS things. So being granted within just 2 3 months, while paying 5,000, and now open access and open things are they are just having more and more things predatory, everything what he has explained into that, they are popping up because the popularity, but this is slashing down because this your core journals and all these things are coming out, and open access, everything is going, that is different. All other literature is different, but this patent and IPR is different. But filing a patent is definitely a very fruitful avenue for the library professional. It's good that you have shared this. Anything, anybody else?
It's almost completed, sir. You have covered all the questions.
No, and in fact, what happens? Question is more easier to explain more things which are hidden behind the knowledge base. That is more because I cannot flash each and everything on the slide, whereas our discussions will be more fruitful in this case.
Sir, generally I'm asking if
Ah,
there is a patent
ah,
which is applied with some specifications, everything.
yes.
So that the basic structure is one same thing for structure of
It
any
is
product.
same thing.
And
Sir,
another will come with a
there is INID number, sir.
Hmm.
If you go to my preliminary side, INID, International Numbering System is given. 54 means abstract. If I want to see the abstract of the patent, I will just click to that part 54, I will see the abstract only. Or from the patent databases, I can field search also. Abstract or 54 section, that will be searched.
But
That is very good, sir.
in case somebody comes with a slight changes of a product
Ah,
and description will not give as it is.
ah.
So how can we identify and would it be considered as a patent or copying patent or something?
No, that is based on the patent claim only.
Patent claim.
Patent claim are the unique boundary for the getting rights for right holder.
Okay.
If your patent falls, then whatever good material may be there, it will not be granted.
Okay.
So patent claim is the basic element for granting the patent. So as I told you, there are patent databases which are just only highlighting claims, patent claims. You can search. Chemistry databases are very popular, that I have searched for that. And everywhere this Derwent, then in paddock patents and all these things, they based on this patent claims only. If your patent claims are duplicated, then there is no way of granting the patent, because the purpose of claiming what you are claiming, that is not fruitful, so your patent will not be granted.
Right.
Yeah.
Thank you, sir.
Yes.
Thank you. Any questions more? I
Yeah,
see some
anybody
hands
can
up.
ask, no
Thank
problem.
you, sir.
Even I cannot reply, somebody else will reply.
Yeah,
That
no,
is
sir.
not a problem.
Thank you, sir, once again.
Thank
And
you.
may I now request Saheli Atram to give her vote of thanks so that we can wind up the session for today.
Yes,
Yes,
sir.
sir.
Yeah.
Good
Good
evening,
evening,
everyone.
everyone.
It
It
is
is
my
my
proud
proud
privilege to
privilege to
purpose to
purpose to
vote
No
of
vote
problem.
of
You
thanks
have
on
logged in
behalf of.
twice, mobile and other. Please either mute one or try to, yeah.
Yeah, it's okay, sir, now?
Yeah, perfect, perfect.
Yeah. Good evening, everyone. It is my proud privilege to purpose to the vote. Thanks on behalf on the Indian Librarian for today. Skill Enhancement Program on Research Methodology and Innovation in Scholarly Communication. First and foremost, I extend my sincerely gratitude to our respected dignitaries, Dr. Pradeep Rai, sir, President of ILA, Dr. Mohan Khede, sir, former President of ILA, Dr. Parshuram Kattimani, sir, Senior Vice President of ILA, and Dr. Dharam Kumar, sir, General Secretary of ILA, for their constant support, blessing, and encouragement which have made today's workshop meaningful. A very special word for thanks to our eminent resources person, respected Dr. N.B. Dahibate, sir, retired Principal Technical Officer, CSIR Pune, Maharashtra. Sir delivered a highly informative and insightful talk on the topic patent filing, process and case. Example. The way you explain the procedure of patent filing, share a real case studies and highlighted the importance of patents in protecting innovation has been extremely valuable. Your knowledge and experience will definitely inspire all participants to strengthen their understanding of a practical aspect of patent filing. I also extend heartful thanks to our patron members, Dr. Abbas Sir, Dr. Virej Hanchinal Sir, Dr. Ashok Khobragade Sir, Dr. Sambhaji Patil Sir, Dr. Bhoop Singh Verma Sir, for their valuable association and continuous encouragement. My gratitude also goes to the organizer team, Dr. Milin Anasane Sir, Dr. Vinita Jain Ma'am, Dr. Shiv Shankar Prasad Sir, and Dr. Vishal Bapte Sir, whose tireless efforts have ensured the smooth organization of this event. Special thanks to our coordinators, Mr. Rahul sir and Mr. Shubham Masurkar sir, for their excellent planning, technical support, and executive of today's program. Last but not least, a big thank you to all dear participants. Your active presence and engagement have made this workshop truly interactive and successfully. We kindly remind you all fill out the feedback form which will remain open for the next 30 minutes and certificate will be issued accordingly. Once again, on behalf of the ILA Library Indian Library Association, I extend my deepest gratitude to everyone who has contributed to the successful of this workshop. Thank you to all. Thank you, sir. Thank you so much
Thank
for the
you.
guidance. And Dr. Shiv Shankar Prasad, sir, over to you, sir, now.
Thank
Thank
you. Thank you.
you, Saheli, for giving a wonderful vote of thanks and complimenting everyone. Thank you
Thank you, sir.
once again to our today's resource person Kumar sir, ILA President, ILA Secretary Dharam sir, and Vice President and West Zone office bearers, everyone. And my request to the participants, you kindly take ILA membership if you have not taken till now. It's a very nominal cost. It's a life membership. It's around 1550. You can apply online also. Try to join with us so that we will be more stronger in the future too. So I request you all of you to take your membership and join for tomorrow's session, day after tomorrow's session. Don't miss the sessions and try to continue the program. Thank you once again. Once
Thank you,
again,
sir. Thank you,
all the
sir.
best.
Thank
Thank
you.
you.
Thank
Thank
you.
you.
Thank you, sir. Thank you.
Thank you,
Monica.
sir.
Thank you,
sir.
Milind.
Thank you,
Thank
madam.
Thank you, Shubham. Everyone. Thank you, Rajesh. Everyone.
Thank
you.
you.
Thank you.
One and all.